Okay, everybody, as the clock turns to 1 o'clock here, why don't we get started? We'll have some preliminary comments to make, which will allow some others to join us along the way. But thank you, everyone, for joining us on this presentation today. Couple of preliminary matters. If you have questions during the course of this session, you should have access to the Q&A chat session component on the webinar. Please feel free to send those our way. We'll do the best we can, Matt and I, to get to all the questions. We may have to save some to the end. This session is scheduled for 1 hour. We will, again, try to do our best to hold it to that time frame, but if we run over, if we have questions and people could stay with us, we'll stay as long as needed. If you want a copy of this presentation, and it is being videotaped for the audio or audio taped as well, we can send you the audio and the slides afterwards if you just send us your email information. So let's get started. My name is Dennis Cotter. I am the co-chair of the Smith-Amundsen Construction Practice Group, along with Matt Horn, who's also on this call. Matt is also our national OSHA and our construction transactional lead partner. We both work very closely with our various practice groups in the firm, but in these interesting times, we are working very closely with our Smith-Amundsen COVID task force, which is an accumulation of specialists in our employment group, banking and finance group, our corporate transactional group, insurance services, et cetera. We have resources in that regard. I know some on this call have taken advantage of them, but on our website, which is www.salawus.com, there is a myriad of resources all in one place, hopefully in a format that allows you to cut through some of the noise that you're getting as it relates to the issues that are impacting your businesses on a day-to-day basis. I do want to make one comment based upon the recent news in the last couple of days. I am hoping and praying, as I know all of you are, that we might be turning the corner on this, at least in some parts of the country. Let's all collectively hope that's the case. But the reality is that the issues that it's creating right now in the moment, and the issues that it's going to continue to create are going to be with us for a while. So what Matt and I would like to do today is try to help you that are in the construction industry or in some way related to the construction industry focus on what we think are 3 of the critical issues that you need to be thinking about today, and helping you in the construction industry try to parse through so much of the information that you're getting that's directed to commerce at large. So that's our focus for today. The 3 areas that we're going to be focusing on primarily, and I'll turn it over to Matt to start this, will be the delay in contracting issues that you might be facing right now, the OSHA, CDC compliance and other safety compliance issues, and then Matt will hand it back to me to talk about some of the insurance and the claim and the risk issues that you may be dealing with currently. And before I hand it off to Matt to start this presentation, I do want to say that there are, as I'm sure you know, there are fantastic resources through a number of the industry associations that you can access. And I do want to note one, that your Chicagoland AGC, not to single them out to detract from the others, but just that they have been right on top of these issues from the moment they've started. And you got Mike Kasulich over there, and Tom Kasulich and Mike Hampson. And if you've got any resource that you want to access, that you're trying to stay on top of the issues, I would suggest that that's one that you at least want to look at on a day-to-day basis, the Chicagoland AGC. For example, just an hour or 2 ago, they sent out an alert, and I won't go into the details, but it addresses the issue of trying to get approved for SBA loans through the payroll protection plan, and how it dovetails with the paid leave mandates, and how it, on the issues of what qualifies as a small business. for the hundreds of thousands of of construction companies that have, less than 500 employees. And there's some great guidance there and some insight for that. So at this point, let me turn it over to Matt to take it from here to talk to you about delay in contracting issues in the OSHA and CDC compliance. Matt?
Good afternoon, everybody. The one thing I want to point out is this presentation is it's a practical presentation. There will be no theoretical discussion here. We will be talking about the issues that people are facing now and how we suggest that you address those issues. One thing that's unique about our practice is, we don't just represent general contractors or subcontractors or owners or developers. We represent everybody. So we're dealing with these issues on behalf of all of the parties involved in a construction project, which gives us a unique perspective as to, what's happening out there and how to respond to those things. As we all know, there is a stay-at-home order currently in place. And as I assume we also all know, construction is largely exempt under sections 9, 12H, and 12T. When the stay-at-home order was issued, we got a lot of emails and calls about, okay, I do this type of construction, am I exempt? And the reality is the wording of the order is so broad that it encompasses virtually all construction activities. So what we told our clients is, to the extent that you can move forward with business as usual, do it, because your construction work is exempt. We didn't know at that time if municipalities or cities or counties or anyone else would be trying to issue supplemental guidance, basically saying that construction is not exempt. But so far, we have heard from none of our clients that anyone has tried to stop them from working. And so, we have clients that do pools and, that do roads. And so it seems that everyone acknowledges and understands that all construction activities are covered under the order. So that is to say, is it business as usual? And I think, once people saw the order, they were hoping that would be the case, that they really would be impacted. And our experience is that, while many companies are allowed to work, business is not going as usual. And so what are we seeing? The biggest thing that we're seeing is the delay issues. The second issue that we faced once we got past the delay issues were projects being suspended, projects being terminated, owners telling people that they weren't going to be able to pay them. And then the third thing was, what's OSHA doing? What's the CDC doing? What do they expect us to do to continue working? And then the fourth thing that we're now looking at, and we just learned that there was the first COVID lawsuit filed in Illinois a couple days ago. So now we need to start thinking about, okay, what are the insurance ramifications? What types of claims are we going to be facing? What type of litigation is involved? And so we're going to cover all that today. As to the delay issues, and this is the one that, even before the order was issued, people were sending out delay notices because they had heard that the order was going to be issued, basically saying, this COVID-19 issues out here, there's a pandemic, we're going to be delayed. And so I know a number of my clients received those notices and, of course, immediately forwarded it on to me and said, how do we deal with these? So we've seen that. We saw that, the peremptory, hey, COVID's here, we're going to be delayed. And then, all of those notices really provide no explanation as to how they're going to be delayed or how long they're going to be delayed or any of those things. And so, a bunch of people sent those out, and frankly, I was a little bit confused by it. We also learned, and a number of our clients dealt with subcontractors just saying, well, we're not going to work. We're not going to work while this pandemic is taking place. And, there were lists, and I'm sure many of you saw them, circulated with contractors that said that. And Again, they didn't provide much explanation other than, hey, COVID, so we're not going to work. And I think that's ultimately going to create a number of issues for those contractors that have done that. So, when you look at, and delay issues are a creature of contract, right? So you need to look at your contract as to what it says about delays. But most contracts say when you have an actual delay, you need to tell your client, your upstream client. And so what we've told our clients is, listen, let's not send out a general preemptory notice. Everyone knows COVID is going on. Let's see how it's going to impact you, if it's going to impact you at all. And if and when it does, and there's an actual delay, then let's send out a delay claim. So what types of actual delays are we seeing? We're seeing companies where workers have the coronavirus. And, it's not just one worker, half the crew has it. So if you have to shut down that crew, obviously, and you're going to have to comply with CDC and other things, that could be a delay. Workers can't work safely or in compliance. I know that some of the contractors that sent out those preemptory COVID delays that didn't really explain why they were delayed, later came out and said, well, our employees work in clusters and they work in close proximity, and they can't do that work when they're required to distance themselves or socially distance themselves by 6 feet. And I think a temporary delay to figure out how to address that may be valid, right? And we'll talk about that. But so if you guys can't work and be in compliance with the OSHA and the CDC guidelines, that's a potential actual delay. The other one, material, supplies, contractors, not available. I had a lot of clients that were waiting on material from Italy or somewhere else, and those countries shut down, so they weren't getting those supplies. I also had clients with material suppliers that weren't working, so concrete companies weren't sending out their trucks, so they were delayed. That's an actual delay. No inspections and permits. So where the project's located, the government unit's not doing inspections or issuing permits. And I know City of Chicago is continuing to do this. I have heard that some suburbs on the North Shores are not conducting inspections. And obviously, if you can't move forward with your work without getting an inspection, that's going to result in a delay. So there are many actual delays. Our suggestion is wait until you have an actual delay on your hands, or expect to have one before sending out a delay notice, because just sending out a general, hey, COVID's out there, we're going to be delayed, has seemed to create more headache and confusion and hassle than help. The one thing in Illinois is you can't just have a delay and rest on your laurels. There's a duty of good faith implied in all contracts in Illinois, and that includes with respect to delays. So you're expected to take reasonable steps to try and resolve the event causing the delay. And the reality is most construction contracts require you to do that. And if you don't do that, your client can usually accelerate your work at no additional cost, require you to hire more workers, require you to work longer hours, all of those things. But if you are delayed, you need to take steps to resolve it. You can't just sit at home. And I know contractors generally don't do that, but I have heard of some people just saying that they're basically going to wait out COVID. So what can you do? If your clients are in close proximity, adopt a mask or a respirator program, right? No need for social distancing if everyone's wearing a mask or a respirator. Find a new supplier if your supplier can't get you the materials, and if you're having a workforce issue, hire more workers if that's possible. So remedies for delay. There are typically 2 remedies for delay. And so for force majeure, epidemic, quarantine, and delays beyond the control of the parties, and those are the 4 that you'll typically see in a construction contract that pertain here, you're almost always entitled to extra time. In some contracts, for those delays, you are entitled to extra compensation too. So again, what you're entitled to for a delay claim is a creature of contract. Even if your contract has a no damage for delay provision, you still might be entitled to compensation for those delays if the delay issue, the coronavirus, the pandemic, the delays that it has caused, were not anticipated in the contract. And so the exception that the courts recognize is a delay beyond the contemplation of the contract. So preserving a delay claim. What do you need to do now if you haven't been delayed? I mean, you understand coronavirus is out here. You understand that it's impacting a lot of people, but it actually hasn't delayed your work yet. What should you do now? Well, you should go through and you should look at all of your contracts. And you should identify what your contracts say regarding delays. And so the things that you need to look for is, first off, what constitutes a delay under the contract? And identify, what this current situation, this delay, which one of those delays it falls into. Second thing is the time frame for letting your client know about the delay. And that's why I really encourage people to look at these provisions now, because some contracts will require you to give notice of a delay within 24 hours. I mean, I've seen it as short as 24 hours. And so the typical time for giving a notice of delay is usually 2 to 7 days. I've seen up to 14 days. But so the reason that I'm suggesting going through these now is these periods can be very short, 1 or 2 days, in which case, if you are delayed, you want to make sure that you get the notice out within that time frame. The other things that you need to look for is, what are you entitled to in the event of a delay? Are you entitled to additional time? Are you entitled to additional compensation? And then if you are delayed, what is your client able to do with regard to making up that delay? Is it entitled to require you to accelerate your work, require you to hire more workers, require you to work longer hours? And if they are able to do that, are you entitled to compensation for that? The other thing you need to be aware of when you're looking at delay claims is, if they reject the delay, what is the claim resolution requirements in the contract? So when you're looking at the delay claims, I would look at those two. So, and then what do you do once you've been delayed? So I suggest going through your contracts, creating a summary of all those relevant provisions. You can usually just cut and paste them in, put them in a spreadsheet. And then what do you do once you're delayed? Then you got to start sending out the notice to your clients that comply with the contract, right? So you need to send the notice out within the time frame. You need to explain the things that are required. You need to, if they require you to estimate the length of the delay, the cost of the delay, just make sure that you comply. What if you have downstream contractors? So if your downstream contractor notifies you of a delay, the best thing to do typically is to pass it upstream. If you think that it's not valid at all, you can ask them to withdraw it. And if they'll withdraw it, maybe that puts it to rest. But if they won't withdraw it and they force it, the best thing you can do to protect yourself is to pass it upstream, even if you don't agree with it. In the delay, explain and document the basis for the delay, right? So, and again, I saw some delays that just said, we've got this COVID pandemic going on. We're probably going to be delayed. It's probably going to cost more money. And that just doesn't help, and it doesn't comply with the contract documents. You got to explain why you're delayed, and then explain and document the impact on your work, right? So I'm going to need additional time. I'm going to need additional compensation, and here's why. And then explain the steps that you are taking to minimize the delay and the impact, right? That's the best way to kind of soften a delay notice, is to say, well, we're doing these things to try and lessen the delay as much as possible. So those are delay claims. With regard to project suspension and termination, and I just started seeing these coming in late last week. So, it seems that all of these COVID-related things come in waves. The first 2 weeks, the big thing was the delays. Now I'm seeing project suspensions, terminations, owners saying they're not going to pay. And so that's the issue that I'm really deep in right now. So, one of the things is lenders are suspending and terminating projects. Owners are too, right? Money's tight. You know, I mean, you had these businesses, the economy was churning, everyone was making a ton of money, and it came to a grinding halt. And the first thing that people are doing is they're suspending or terminating capital projects and construction projects. Also, I've heard that owners, lenders, and especially title companies are not processing payments. I was talking to one of my clients today, and you know, they've said that a couple title companies are still really good and working remotely, but that some of them, you know, are just not working at all. And they're telling people to send documentation to their offices, and then there's nobody at their offices to process it. So if you're running into any of these issues, if your project's been suspended, if it's been terminated, if you're not being paid, you know, review your contracts closely to determine what your rights are, right? Typically, you have the ability to stop work. Typically, you have the ability to obtain payment for work completed and costs related to the suspension of work, the termination of the project, and things like that. But if you're learning about any of these things or any of these things are happening, start preparing for them. Then what do? Then submit the payment application, right? So if you're owed money for completed work, if you're owed money for other costs that you're entitled to relating to the suspension, the termination, or the non-payment, you know, get those payment applications in. If you think payment's going to be an issue long term, I've heard that a lot of these lenders and owners are saying, listen, we intend to start this back up, the project's back up, you know, once this pandemic is over and once the money's coming back in the door. But how long is that going to be? Is that going to be 1 month? Is it going to be 6 months? You know, we don't know. So, you know, the one thing that you should be doing is if you're not getting paid for whatever reason, then you need to start evaluating your mechanics lien and your bond rights. And so for general contractors, the best case is recording your liens within 4 months of your last date of work. And for subcontractors, second-tier contractors, you know, you need to send out the 90-day notice within 90 days of your last date of work, and then you need to record a lien. I will tell you, you know, in situations like this, I've been involved in a number of projects that have been suspended or terminated for reasons unrelated to COVID, and the quickest way to get paid is to perfect a mechanics lien on the property. So OSHA and safety issues. So this one's obviously been going on even before the stay-at-home orders and things like that, but it's really become amplified. And you know, just the other day I read the first article I'd seen about construction workers feeling like they're not being protected, and you know, that nobody's considering them and nobody's considering their safety, and everybody's looking at, you know, the healthcare workers and the retail workers and the truckers, and you know, the construction workers aren't getting their fair attention. And so, you know, there's some good elements to construction in this context, and that is OSHA has issued guidance basically saying that construction is considered low risk for COVID. So who do we have that's really high risk? You got everyone in the healthcare industry, right? Then you got the retail workers, you know, you got the Amazon delivery guys, you got teachers and people that interact with the public, and then down at the bottom, you've got the construction workers and the people that really aren't exposed to the public. So OSHA said that we're low risk, which is great. Part of being low risk, OSHA has also said that there's no additional PPE required for our employees to work. And so this is where we really start getting into, and I'm sure you guys are all receiving the emails and you're all, you know, tangentially tracking the guidance, but there's just so much conflicting guidance out here. I mean, even within the CDC, then between the CDC and OSHA, between the CDC, OSHA, Illinois, Chicago, I mean, you know, it just gets overwhelming. So, you know, we've looked at all of it. I tried to boil it down. There's so many exceptions, so many different criteria, but I've tried to boil, you know, the guidelines down here. And so what people are saying is CDC says that 3 days need to pass with no symptoms for workers with COVID, right? So if you have a worker with COVID, they've actually said they can come back to work the later of 7 days after they've first shown symptoms or 3 days after their symptoms have been resolved. So it seems to me that that criteria will always be 3 days after symptoms have been resolved. So they're saying that, you know, if you have an employee with a confirmed case of COVID or a suspected case, once 3 days have passed with no symptoms, they can come back to work. The CDC just issued guidance yesterday for critical infrastructure employees, which I think there's a strong argument under the orders that construction is included in that. But the CDC has said that even when you have an employee who is exposed to COVID but doesn't have it, so let's say the person he's working with has it or the person's spouse has it, that they can continue working as long as they're wearing a mask. All right, so this was just issued yesterday. And of course, we have many things conflicting with that. So we have unions weighing in. I know that the laborers union sent out a comprehensive letter that there was some uproar about that they're working on revising. We've also seen cities weighing in. And so yesterday I saw the city of Chicago's guidance, and Chicago had said construction workers absolutely keep working. If you have a worker that has COVID, they provided the same guidance as the CDC, so 3 days need to pass without symptoms. But Chicago has said that if you have a worker that is exposed to someone with COVID, that they need to stay home for 14 days, right? And so that becomes very difficult to manage. And then the question is, all right, do I follow the CDC guidance? Do I follow the Chicago guidance? Which guidance should I follow? And it's a difficult question. And the reality is, if you're in Chicago, you should probably follow their guidance. If you're outside of Chicago, you know, CDC and other things seem to be working. I do have a question here. It says, is it true that construction work in hospitals where patients are being treated for COVID-19 would be considered low risk? I would say absolutely not, right? So that's very high risk. High risk, just like a healthcare worker. I mean, if you're in a place where people are coming intentionally with COVID, that's high risk. So some other OSHA and COVID issues. OSHA just issued guidance saying that it will require employers to record and report employee COVID cases in certain circumstances, and there needs to be 3 criteria satisfied. An employee has a confirmed case of COVID. So that's a pretty big step. I know it's hard to get tested, so it's hard to get a confirmed case of COVID. The case is work-related, and the case involves one or more of the general recording or reporting criteria: medical treatment beyond first aid, days away from work, hospitalization, death, etc. In order for it to be work-related, the employee has to be infected at work, right? So it's not enough that he and she gets it at home from their spouse or their kids and then comes into work. And I think OSHA really issued this guidance for healthcare providers, but of course it applies to all employers. So, you know, if you have a confirmed case of someone on one of your sites and the guy that he's working with gets it 2 days later and he gets a confirmed case and he tells you that no one he knows had it except for the guy that he was working with, then you could potentially have an obligation to record it or report it. We have another question. If a worker is home for 14 days sitting out a COVID-19 stay-at-home due to exposure, is he covered by workers' compensation during that period? The reality is I can't answer that question for you. I'm not a workers' compensation attorney, so I would defer to them. Generally, I would think that it's not. They're not covered by workers' compensation because if they're just sitting home, they haven't had an illness or an injury. But I'll defer to Dennis and to other workers' compensation attorneys for that.
You know, hey, Matt, let me just jump in quickly on that.
Yeah.
Not to get sidetracked on it, but we addressed that a little bit in my presentation, but you are correct in your general statement that it would not be a compensable workers' compensation injury or illness in the context of what we know about COVID and how you can catch it and where you can catch it.
Okay. And so, you know, the good thing is having a national OSHA practice, I talk with OSHA inspectors and area directors daily. And so, it is my understanding right now that OSHA is not conducting inspections. I don't know if that's true for fatalities or not, but generally they are not conducting on-site inspections and instead are allowing employers to self-report. The other thing is OSHA is so overwhelmed with employee complaints regarding COVID exposure that my experience is when OSHA receives one of those complaints from one of your employees, all OSHA is doing is notifying you by a form letter that they received a complaint regarding COVID exposure and that you should be following the OSHA guidance provided to address that. So obviously they're inundated with COVID issues and inundated with employees complaining. And the good news is that construction is so far down the line for OSHA at this point, with their focus being on healthcare providers and retail workers, that construction seems to be an afterthought. So what should we do? Again, just like the conflicting guidance out there about what we're supposed to do with an employee with COVID or an employee that's been exposed, there's so much conflicting guidance out there about what we're required to do, what we should do in order to prevent COVID among our employees. And so the first thing that is clear is, CDC and OSHA wants you, if you're an employer, to adopt, and you're working, and everyone's not working remotely, but they want you to adopt some sort of COVID plan, and that they want you to train your employees on it. If you're a general contractor and you have multiple lower tier contractors on a site, you should require them to prepare and submit their own COVID plan. You can require them to follow your plan. Dennis will probably touch on that a little bit. In many cases, it's better to require them to develop and follow their own plan. But, parsing through all of the guidance on this, what are the elements that should be included in a plan, right? First one is, if you have an employee that has COVID-19 or symptoms, they can't work. They can't come on site until the symptoms are resolved. And if somebody develops symptoms on site, they need to leave immediately, all right? And so the CDC, as I indicated, says 3 days need to pass with no symptoms. And that seems to be generally accepted, right? The second thing is you need to evaluate your workers for COVID. And if they have signs or symptoms, they must leave. And so what does this look like, evaluating your workers for it? It seems that they want you to take their temperature daily, right? And I know that sounds a little crazy, but a lot of people are doing this. And there are 3 ways that you can do it. You can have a service provider, although I heard that the service providers that come out and take temperatures are charging an arm and a leg, and it's very difficult to find one for obvious reasons. You can have the foreman do it, and then you can have each person take their own temperature. They also want you to ask employees on the site questions each day regarding their exposure. So have they been exposed to anyone? Do they have any symptoms? Are they coughing? Do they have a headache? And then, best case is you document those answers and you document the temperatures and you act on those, right? So if somebody has a fever, somebody's coughing, they're off the site until, they're 3 days symptom free. Also, spread the workers out. This is the one that everybody wants to see, is spread the workers out, right? And if you can't do that, if they're required to work together, then require masks and respirators. The other things when spreading workers out is you can stagger start times, designate traffic on stairwells. So one stairwell goes up and one stairwell goes down. And there are a number of things that you can do to spread your workers out. Limit the number of workers in a truck or a hoist, right? So if you're on a high rise, 2 people in a hoist at a time. If you're in a truck, don't pack a bunch of people in the truck. Make soap, sanitizer, and wipes readily available. This is a big one, especially with the hand sanitizer. Have porta potties routinely cleaned and sanitized. do not meet in large groups. And I know that this, somewhat conflicts, you want to have a toolbox talk on safety and things like that, but they're saying not to do that. And then eliminate communal water jugs, coffee stations, and break areas. Additional steps to take to prepare. So those are the things that we're seeing now, right? Those are the three issues that my last 3 or 4 weeks have been consumed with. And, the other thing is I have clients calling me and saying, hey, Matt, we got this new project. Will you take a look at the contract? And so there are things that you should be thinking about for your future projects, right? So review incoming contracts in light of COVID, right? I mean, just like after 9/11, when people started thinking about, wow, the terrorist act could really impact my business. It could shut a project on it. So start looking at your contracts, looking at the delay provisions, looking at the suspension and termination provisions, and any other provisions that are implicated in light of what's happening here. Because, I think hoping that this never happens again is one thing. Expecting that it will never happen again is another thing. And so, at this point, I would be anticipating that this is going to happen again at some point. So when you're looking at those provisions, because we all used to gloss over, I used to gloss over to some extent delay provisions, suspension provisions. It just wasn't a focus, but this has really brought it back into focus. And so you need to be thinking about those things in light of what you're experiencing now. The other one is, consider adopting an emergency illness protection policy, and including masks or respirators. So when it happens again, you can immediately put your employees in masks or respirators. And this is especially true for, the companies that had to shut down because their employees are required to work in large numbers very closely to each other. Those are the people that should really be looking at, okay, should I have 100% respiratory policy? So if this happens again, I can put everybody in a respirator the next day and we can go back to work. And we did get a question. The CDC just recommended cloth face coverings. Should we require all site employees to wear face coverings? A recommendation is different than a requirement. I would say if your employees want to wear cloth face coverings, great, right? Bandana over the face, a surgical mask, even a dust mask. I would let them choose. Would I require it? I wouldn't require it until somebody required me to require it. Because once you require it, it implicates standards within OSHA and may require you to take additional steps. I'm sorry. And at this point, I am going to pass it to Dennis for a discussion on insurance claims and litigation. Thanks.
Okay, thanks, Matt. Do you want to take the steps to just hit the button here? I can pick it up from here. And then we'll get going on that topic, or on the topics that I intend to talk about. And while we're making that transition here internally, what I want to talk about, and my next slide will show this, is 4 things that we've been seeing. We've had clients asking us about here in the last month or so, maybe a little longer. Okay. I think I have it. Okay, thanks, Matt. We'll have time, it looks like, for some questions at the end. We have a few others coming in, and we'll try to address them all if we can in the time that we have allotted. But the issues that I wanted to just touch on, they're an extension of the practical site-specific topics that you just heard Matt talk about. I think that our clients in particular, and those of you that have an interest in this, should at least be aware of what the current status is as it relates to 4 different topics. The first one, can you make a COVID-19 business interruption claim? And I'll talk a little bit about that. That was a common question raised immediately by all companies, not just construction companies. I'll touch a little bit on workers' compensation and occupational disease claims and how they're implicated by the COVID-19 pandemic. Potential contractor liability for COVID-19 claims of a non-employee. And that's a little different spin. That one about workers' compensation and occupational disease deals with if your employees contract COVID-19, what happens if an employee of a subcontractor or a related or affiliated contractor contracts COVID on one of your job sites. And then lastly, very briefly, insurance coverage for COVID-19 claims of non-employees, because it would be workers' compensation if it's established to have been contracted as an injury or illness for one of your employees, potentially. But if it's an employee of a subcontractor or an affiliated contractor, then your workers' compensation coverage would not be implicated, but your general liability third-party coverage would be potentially implicated. So before we go there, I just put a couple of slides in there to keep you up to date on what's going on the litigation front as it relates to COVID-19. It didn't take long. On April 6th, it's Monday, the first Illinois COVID case was filed. It's a wrongful death case, and it's alleging that an employee of Walmart sued both Walmart and the property manager / owner, J2M, seeking recovery for their relative's death. It was their estate that filed the case. Wando Evans is the deceased. And as you can see just from the paragraph there, the general allegations are such that I guess not unanticipated in the litigation world are that the folks at Walmart were required to work in close contact with each other despite social distancing and practical distancing measures implemented. And apparently another employee of Walmart also died. He or she is not a party to this lawsuit. But one of the interesting allegations from the retail world, and not sure what the implications would be for the construction industry, but I think it's important to understand what is happening in the first cases that are being litigated on this issue is, as a retail worker, one of the allegations is that the employees were at high risk for infection due to the volume of individuals present at and circulating through the store on a daily basis. We have no guidance yet as to where this will go, what direction that this case will take. But you get a sense of what the issues are that are being raised. The complaint also alleges that Walmart and the property manager were negligent by failing to properly sterilize the premises, failing to promote and enforce social distancing. I mean, all the guidelines that you've been hearing about, provide masks and gloves to employees. And then back to something that Matt mentioned as it relates to guidelines or regulations, but failing to adhere to the Department of Labor, CDC, OSHA guidelines that have been published and that our various levels of government have rightfully been telling everyone to comply with. What happens in the claim/litigation world is that one of the byproducts of either companies or industries or even the state and local governments trying to implement change in a positive way by implementing guidelines or recommendations, what they ultimately end up establishing is what we call in the litigation world a different standard of care, or a modified standard of care, an altered standard of care. It doesn't mean that those entities should not be implementing those guidelines or recommendations. What it means is that societally and more importantly legally, it does change the scorecard as to what individuals and companies are required to do in order to be acting in what is typically called a reasonable manner as it relates to their conduct and or their function. And that would apply. These concepts, although this is a premises / independent Walmart case, the concepts are a little bit of an insight as to what we might start to be seeing and maybe what we should be thinking about trying to avoid in the construction industry. So the first question we had was, can you make a COVID-19 business interruption claim? Because I've had a few clients several actually, call us and ask us that question. Some in the construction industry, some not. Byproduct of having some of their folks get ill, byproduct of having their folks work remotely and they really function as effectively, impacting the business, byproduct of folks just not wanting to come back into work because they're fearful, and or any combination thereof or otherwise. And the short answer to can you make a COVID-19 business interruption claim if you think you have one to make, that you believe the COVID pandemic has been adversely interrupting your business in a financially measurable way? The short answer is you can make the claim, and my recommendation to my clients is to make it, to preserve it. The longer answer is, will you succeed or prevail? And that answer is, I think that's a difficult road in today's environment. And I'll show you why here in the next couple of slides. That's standard language for a business interruption clause is set forth on the slide. And the key language is that it's typically an interruption of your business caused by physical loss or damage. That tends to be universal in most business interruption provisions in most general liability and business policies. It's physical loss or damage to the insured property that otherwise then causes the interruption to business. So the key question is, in a COVID-19 business interruption claim, is was there physical loss or damage? So the covered perils are, just a little context, are typically in a business interruption claim are fire, flood, other natural disasters. But as a result of the SARS pandemic and other recent not as significant outbreaks, most policies at this point expressly contain language precluding coverage for losses related to viral outbreaks. That said, it's not going to stop companies and creative folks who need the assistance of the business interruption coverage or want to aggressively pursue it from trying to do so. So there's been a recent case filed in Louisiana, I show you on this slide, related to COVID-19. It was a restaurant, and they are now in litigation with their insurance carrier over whether they're entitled to business interruption proceeds. That citation in that case, if you have this issue and are interested, is a good starting point as a roadmap for the arguments that are being made. And what's being alleged in that case is that, on the physical impact or physical damage component, it says the deadly virus physically infects and stays on the surface of objects and materials. And as such, the contamination of the insured premises by the coronavirus would be a direct physical loss. So trying to focus on a very narrow interpretation of how the virus spreads, frankly, and epidemiologically and statistically, there's information being developed on that by the day. But what they're trying to assert in that claim is that the virus actually does, in fact, cause a physical loss or damage because it is on the surface of an object or material by most of the ways that it's transmitted, although there is data, as I'm sure you're all aware of, that it can be obviously transmitted by coughing or in the air for a short period of time. So that's a new case, no decision on that one, nothing concluded, but we're watching that closely as it relates to guiding some of our other clients who have interest in possibly pursuing these claims. On another front, you should be aware of the fact on this issue that 18 members of the United States House of Representatives wrote a letter to 4 major insurance trade organizations and asking them to recognize financial losses related to COVID-19 under the commercial business interruption coverage. And on the same day, they got a letter back, which is attached on the next slide, and I won't read it to you, with the ultimate conclusion that business interruption policies do not, and were not designed to provide coverage against communicable diseases such as COVID-19. So that's the position generally of the insurance industry. That's consistent, frankly, with the basic language of most business interruption policies and the exclusions that exist in some of those policies. That's the letter, by the way, that was sent back. So the other level of attack, and frankly, this is the one that might have the most success, is legislative attempts to require insurance carriers to cover claims for damages relating to COVID-19 on a number of reasons, or for a number of reasons, but public policy, health and safety being the primary one. And in defense of insurers, these policies weren't written to address this type of a pandemic or this type of an occurrence. And taking a position, particularly those that have virus exclusions, that there's no insurance coverage for it is not unjustified. But these are, as we said at the beginning, these are interesting times we're in. And again, knock on wood, maybe starting to see a light at the end of the tunnel. But depending upon how long it goes and depending upon what impact it has on the financial status of some businesses, including construction companies on some levels, this is an issue that is going to continue to be battled, I believe. There's no Illinois proposal at this point, similar to those that are shown on this slide, to attempt to modify or require insurance carriers to provide insurance coverage for business interruption. So the next topic, which I just want to touch on briefly, is if a worker on one of your job sites contracts the COVID-19 virus, is it considered a compensable event under either the Workers' Compensation Act or the Related Occupational Disease Act? And generally, as you can see from the slide, if a worker contracts a harmful illness while on the job and it's related to the employment, which is important, is not in that sentence, they may have a viable claim for workers' compensation benefits or benefits pursuant to the Occupational Disease Act. Occupational disease is defined, as you can see in the next paragraph, as a disease arising out of it in the course of employment, or which has become aggravated and rendered disabling as a result of the exposure of the employment. In the case of an aggravation, it shall arise out of a risk peculiar to or increased by the employment and not common to the general public. Courts will take a look at the factors that are listed in the bottom of that slide. And the bottom line on all of this is there's still going to be a burden as it relates to causation. There's still going to be a burden on the part of the contractor employee for purposes of workers' compensation claims. And I should tell you that I am not an exclusively workers' compensation attorney. We have a dedicated workers' compensation group that deals with the nuances of these claims day in and day out. And I rely on them significantly when I get issues like this. But generally, the COVID-19 would have to be shown to have been contracted on the job site as a byproduct of working on the site at the time that it was contracted. And in part, here it is, because construction, on that issue of proximate cause or proving that the COVID-19 was contracted on the construction site, what will in some ways lean towards that being a burden that claimants could potentially overcome and be successful on is what's shown on the slide, is that construction has been deemed an essential industry and the employees essential employees. So they are exempt from many of the shelter-in-place orders and are allowed to go to work, hopefully with the safety plan of precautions and other CDC and OSHA guidelines that Matt talked about. But because they are working in close, well, not in close proximity, but because they are an essential industry allowed to work and not be mandated by the shelter-in-place provisions that are currently in place, there at least could be a statistical or an epidemiological argument on behalf of a sick employee that the COVID-19 was in fact contracted in the workplace, but that would still be a question of proof on the part of the injured employee for purposes of workers' compensation. next quick area for discussion is what is the typical potential contractor liability for a COVID-19 claim of a non-employee for the employee of another contractor? And I put out a very simple scenario that an employee of a GC, in theory, an employee of a GC has COVID-19, isn't telling anybody, is found out later to be sick, and infects an employee of a subcontractor. At least that's the argument being made. The employee of the sub then sues the general contractor for negligence for allowing its sick employee or employees to be in proximity to other workers and being on the job site, presumably, allegedly in violation of OSHA and other CDC guidelines. Is the general contractor liable or potentially liable for the infection of the sub's employee? And the answer is yes, absolutely, potentially liable for that. But it's not as simple as a subcontractor's employee got sick on the job site, and I happen to know that one of my folks also got sick as a general contractor employee, and therefore I'm liable. It's not that simple. It would hinge upon the proof and the allegations that, in most cases, the contractor who has the claim filed against him, the general contractor in this case, failed to enforce and comply strict adherence with whatever the site-specific COVID plan is, or the CDC guidelines, or OSHA requirements that have been adopted on the job site or otherwise applicable. That will be the area that might cause some contractors to step in it a little bit when they get lazy on these guidelines and these requirements, and then some other worker gets sick and, God forbid, dies because of complications, and then you've got a wrongful death lawsuit filed against your company. And it harkens back to what Matt was talking about earlier, that two things. Number one, it might seem like an overreaction to some folks. I've had a couple of clients say that to me. Most have not. But it might seem like it's a bit onerous. It might seem like it's a lot of unnecessary paperwork and checking workers as they come on the job site. But in this time, number one, for the health of the workers and the health of their families when they go home, it's critical. Number two, from a legal standpoint, potential litigation standpoint, it is very important that all the contractors on a job site, maintain strict adherence to the site-specific and other adopted plans. And number three, personal opinion, guidance I'm giving clients, it's really important that if we see this start to decrease and society starts to come back somewhat, that there's still adherence to these programs and these plans for a continued time based upon the recommendations of OSHA, CDC, and other authoritative agencies, and that everyone just doesn't take a deep breath and stop. And that's obvious, I think, I hope. But until we as an industry and we as a society know that this is behind us, I'm just looking at it strictly as a trial attorney, a litigation attorney who's had to defend just about every imaginable claim you can have. For the good of your folks and their health and welfare and their families, but also, frankly, from a litigation standpoint, you should keep enforcing these site-specific programs well beyond the curve flattening, so to speak, and until we have a much better sense of being beyond this. Last area is, as we're getting up close to an hour, last area is, would there be insurance coverage if, in the example I just gave, an employee of a subcontractor on the job site contracts COVID-19 and let's say in a worst case scenario has complications and dies, and as a result sues other contractors on the construction site, which is typically the case, most prominently the general contractor in many cases. You already saw that's why I put it in the slides, how that issue was playing out in the Walgreens case. And don't think that that's not going to be something that will be considered as a significant potential cause of action or basis for one in the construction context. Unfortunately, it's just the world we live in. So if that's if that case is filed, if that claim is filed, obviously, if you receive it, you would tender it to your insurance carrier or carriers. The question is, would it be covered typically? That's a much longer answer than we can give you right now as it relates to the interpretation of the specific language of your general liability policies. But the issues that may come up in that context are that most GL policies provide coverage for an occurrence. First of all, there has to be an occurrence, and it causes bodily injury or property damage to a non-employee. Excuse me. So the first question here would be, was there an occurrence? And I think that's something that you may want to discuss with your broker, looking ahead, and have your broker or your insurance advisor discuss with some of your carriers in advance of having to see one of these claims come down the pike, whether they think there would be insurance coverage or applicable coverage for a claim like this. But there is a potential that although occurrence is defined as an accident, including continuous and repeated exposure to substantially the same harmful condition. So there is the continuous and repeated exposure provision in the definition of occurrence, along with accident. Not so certain based upon our research. And again, I have an insurance coverage group that does all of this stuff day in and day out, 24/7, that we could rely upon for further input. Not so certain that contracting the COVID-19 virus is going to qualify as being exposed to continuous and repeated exposure. I think, as I said earlier, the more likely potential exposure to a contractor for someone getting sick and, God forbid, dying from COVID-19 on a construction site is going to be the failure to adhere to your safety plan program, your COVID plan and program, CDC, OSHA guidelines, et cetera. Last comment on the third-party claim. In the event that you have an instance that I just described, is that there are certain exclusions in the general liability policies, and certainly some of them could come into play. Some manuscript policies have the communicable disease exclusion, which appears to be directly on point. You should check that and be aware of it. The mold exclusion, I've heard some folks tell me that they were concerned about that, and I won't speak for the insurance carriers, who can speak for themselves as they interpret their policies. I don't think that would apply, in my humble opinion, because it deals with bacterial substances, and the COVID-19 is a viral infection, which is a different animal in the sciences. And then you have the last one that I note here to be aware of is the expected or intended injury. That there's an exclusion for bodily injury or property damage that results from either an expected or intended injury, with construction being a necessary industry, and having employees coming into contact, or at least on the same job sites, when the rest of society generally in this country is not. Is that potentially something that an insurer could raise as a denial of coverage to a contractor who is sued in a claim involving COVID under the context of the industry right now? I think that'd be my opinion. I don't mean to speak for insurers. I think that would be a tough one, because the federal government on down has said that that's an acceptable practice. But that's the type of exclusion that at times can be raised in situations like this. So that is the end of our presentation on those key topics that we identified at the beginning. We've had a couple of questions that harken back to Matt's section. I don't know, Matt, if you want to address them. One is, how are we supposed to get PPE to our folks when we can't even purchase the gloves or the mask at this point on the market?
Sure. Yeah. And so I'm able to see those questions now. Let's see. So yeah, if you can't find the PPE, well, OSHA has said that you're not required to even have additional PPE because we're in constructions in the lowest classification, not being exposed to the public, not being in the healthcare industry. You know, OSHA has also put out guidance indicating that if you can't get PPE, you know, basically that they're doing a soft waiver of some of their requirements. OSHA's even gone so far as to say that people shouldn't be stocking up on PPE because it's taking it away from the healthcare providers. So all you can do is the best you can do, right? So, get your PPE if you can. I know that they have said that if you're required to wear a respirator, but by the nature of your work, that you still should be adhering to those requirements, but you can reuse respirators and things like that. So, do the best that you can. What about contractors working in partially occupied structure? Could a contractor be held liable for spreading COVID-19 to occupants? As Dennis indicated, and as anyone who on 294 has seen, personal injury attorneys are aggressive, they are creative, and oh, by the way, the courts are closed right now, so they have nothing but time on their hands. So I think you're going to start seeing COVID personal injury attorney billboards popping up on 294 between the Brian Urlacher Hair Restoration and the Illinois Hammer ones. So, the reality is, if you have an employee that potentially gives somebody COVID, there could be a cause of action there. And I think that the personal injury attorneys are going to aggressively pursue those. The question is, what are the courts going to say? Are the courts going to say, listen, no such thing as a COVID claim? Is the legislature going to step in? I heard that Illinois took some measures to protect medical professionals from medical malpractice claims during this pandemic. I think it's going to be really interesting to see how those play out, but are personal injury attorneys going to pursue those claims? Absolutely. And that's why you need to comply with the guidance out there, because if you comply with the guidance out there, then you can say, I did what I needed to do. I did what I was required to do. And so, I'm not negligent. I've complied. The one thing I would note is in your policy, I would not go beyond. I would not push the limits of, well, what can I do? How far can I go to protect people? Because unless you think you can actually comply with all of those things, right? So if you're going to put something on paper, you need to adhere to it. The bottom two, there's one, if the general contractor says you need masks and you can't get them, what can be done? Again, if you can't get them, you can't get them. And if they're saying you need it, then that's when you submit your delay claim. And you say, you're requiring me to get these. I can't get them. Until I can get them, we're delayed. Here's my delay notice. I'll let you know when I can get them. We've got one, do all disposable respirator users have to be medically cleared and fit tested prior to using due to the fact that they are being required to use them according to OSHA? OSHA did put some guidance out on this a couple days ago, or maybe last week. I think they have said that they are temporarily waiving the medical clearance requirement because most of those providers are shut down. So there is no medical clearance being done at this time. But this is my off-the-cuff recollection that every other requirement, including fit testing, is required. So they have rolled back some of the obligations if you're going to adopt a respirator policy now. But, my takeaway from it was they want you to adhere to the majority of it.
There was one question here that was related to what does it mean if you have to prove a causal connection between, say, in the workers' compensation context, a worker contracting COVID and then being able to establish that it was contracted as a byproduct of his or her employment. The short answer is that it is a predominance. It's more probably true. Preponderance of the evidence is that you have to establish it's more likely than not that the illness or injury was contracted in the course of employment. It doesn't mean beyond a reasonable doubt. It doesn't mean to be without a doubt. Without a doubt, it means more probably true than not, which not unusual with either communicable diseases or other similar types of claims in other contexts. What happens is the party making the claim or through their counsel can make that allegation, but in order to establish it, they either have to have direct evidence, which is difficult, or they typically have statistical or epidemiological evidence and experts that will testify to those issues as they're related to the work being engaged in by that employer at that time. So that's what's meant by you still have to prove causation. That it's more probably true than not that the worker contracted that illness on that job site while working for that employer. I think that pretty much wraps up the questions and the presentation. We do appreciate you taking the time to sit through this with us. We hoped we nailed 3 of the key issues that we see as a practical matter coming up daily in our practice and pass some of that along to you. You can email wherever you got the request or the invitation to attend, and we can send you, if you want the audio tape, we can send that. If you want the slides, we can provide those if they haven't been provided already. And certainly, if you have any follow-up or other questions, you can contact either me or Matt directly. We're happy to have a discussion with you. Matt, is there anything you want to add?
No, that's it. Thank you, everyone, for your time. I know everyone's extremely busy right now.
All right, thank you. Bye-bye.
Bye.